The Farrell Law Firm implemented virtual estate planning years ago, and we are able to fully serve estate planning clients with video conferences, email correspondence, and phone calls. COVID-19 has become a pandemic, and as the cases continue to grow, more individuals and families will be put at risk, especially our oldest generations, those with weakened immune systems, lung conditions, chronic diseases, and importantly, those that take care of us, our healthcare professionals. This potentially life-threatening disease can overcome the immune system of its victims and require quick healthcare decisions. These decisions have to be made immediately, but at a time when you may not be able to make the best decisions. Meanwhile, the markets have been in a free fall. Interest rates are at historic lows, real estate values are plummeting, the immediate terror of the aftermath of 9/11 is being combined with the market conditions of the Great Recession. Governments around the world are invested in spending us out of the recession. Now, more than ever, it is time to protect your family and seize the opportunities provided by the falling markets. These are the estate planning steps you should be considering. Healthcare directives are there to provide for directions for healthcare decisions and to appoint decision makers for healthcare treatment. But what is an advance directive for healthcare? It's a legal document, sometimes referred to as a healthcare power of attorney, that is commonly made part of your overall estate plan. As the name states, it relates to healthcare decisions. A healthcare directive can include instructions from you to your future medical providers, but may also be called or include a living will. These are the legal documents which guide doctors and hospitals when making medical and end-of-life decisions when you aren't able to do so. Since these documents only concern your life, they have little application once you die. The advantage of having an advance directive is that these health decisions are already made, saving your family stress or even a legal battle when they should be focused on your health. It also gives your family guidance as to what you're thinking and whether you want their focus to be on fighting for your life or loving you and letting you go peacefully. These are decisions that may change as you age and should be revisited periodically. As long as you're able to clearly communicate, even if you're in pain, doctors will continue to rely on your input rather than your advance directive. They'll only turn to the advance directive when you are no longer able to respond to questions and make decisions. The advance directive gives guidance, but with modern medicine, there are many different ways to apply your directives. So if possible, your doctors will still look to your family or your appointed agent to help with the details of those decisions. With this document, you can name another person, your agent, to handle your financial affairs while you're alive. A power of attorney can be limited or broad, temporary or permanent. It's important, however, that the power of attorney be durable, which means the power granted to your attorney-in-fact continues if you become incapacitated. It is valid in all states. It is sweeping and powerful, and careful consideration should be applied to the selection of your power of attorney. There are two basic kinds of estate planning: will-based and trust-based. Wills are the foundation of will-based plans, and trusts are the basis of trust-based plans. A will is essentially a letter to the court explaining how you want your assets to be distributed following your death. It does not provide for any lifetime powers to anyone. Many think a will means that the estate will bypass probate. It actually guarantees probate. The costs of probate are normally borne by your estate. National averages for the cost of probating an estate have been benchmarked at between 2% and 8% of the gross value of the estate, which is all of your assets and any life insurance proceeds that are in your estate. If you want to bypass probate, you can pursue a revocable living trust. You will still need a short form version of a will, whether you choose will-based or trust-based estate planning. However, with a trust-based estate plan, the will takes second place. Why do you still need a will in a trust-based plan? A testator signs a will to give directions on who will get his or her assets. The will also names an executor to handle the estate. If your testator has minor children, a guardian may be named. Trusts are often formed to ease the transfer of assets to beneficiaries. A trust is a contract for the treatment of property assigned to the trust by the settlor. If property is titled in the name of the trust, it gets treated as determined by the trust, not as adjudicated by the probate court. The settlor signs a document that contains the terms of the trust and names beneficiaries. At that point, the trust is an empty vessel. The settlor must transfer property to the trust, which is called funding the trust. This is called a trust-based plan because the settlor's intention is that their property pass to beneficiaries through the trust and not by probating their will. A trust has the added benefit of assisting you during periods of incapacity or disability. In a will-based plan, if you become disabled or incapacitated, your family has to pursue a guardianship or conservatorship proceeding. Trusts typically are not filed with the court. It's likely that your assets will pass to your heirs in a confidential manner. Would you like your estate to be distributed to your heirs as quickly as possible? If so, trust-based estate planning may be your best bet. An estate based on a will must pass through probate. This process can take months, and complicated estates may take longer. However, your trust may distribute your assets very soon after your death. Trust assets generally do not pass to heirs through probate. How quickly the transfer is made depends on the type of trust. Some trusts are structured to last for years, while others terminate upon the grantor's death. Conversions, coupled with the creation of an accumulation trust to take advantage of discounted investment values, create real asset protection for heirs, avoid IRA proceeds from being included in a marital estate in the event of dissolution proceedings, and soften the impact of the Secure Act provisions. A Roth conversion refers to taking all or part of the balance of an existing IRA and transferring it into a Roth IRA. When taking withdrawals from a traditional IRA after you turn 59.5 years old, you have to pay taxes on the money your investments earned, and on any contributions you originally deducted on your taxes. However, with a Roth IRA, as long as you meet certain requirements, all of your withdrawals are tax-free. Converting the assets now may be beneficial as most people have depressed values of their investments. Under the Secure Act, enacted at the end of last year, all qualified retirement accounts must be distributed to the beneficiaries within 10 years of death, with some exceptions, so that taxes can be collected. If the funds are held for the entire 10 years, then income in that final year for the beneficiary will include all of the qualified retirement accounts. If you want to protect your beneficiaries by creating a trust with asset protection provisions, which include provisions that protect the monies from divorce proceedings of the beneficiary, you have to leave the funds in a trust for the beneficiary. These trusts can also match your core values with distributions to the beneficiaries. For example, you can have distributions for their supplemental income in retirement to purchase a home, foster education, or other values. If you hold the funds in the trust for longer than 10 years, that means you will subject the trust income to federal tax rates of 37% and state income taxes too. While the Roth IRA must still be distributed within 10 years, it can still stay in the trust protecting the assets from creditors. Since the distributions from a Roth account are tax-free, your beneficiaries can let the Roth account grow and then take the entire distribution in year 10 with no tax consequences, or allow them to grow within an accumulation trust that matches your core values with distributions to the beneficiaries. While your assets have depressed value, you may want to protect the upside return in values. The change between the existing value of assets, equities, or investments can be sheltered from creditors. This is accomplished through the creation of an irrevocable trust for asset protection for you or your spouse, coupled with the sale of an installment basis or gift of the assets to the trust. The assets remain available to you or your spouse post-transfer, but are unavailable to your creditors. The type of trust will vary depending upon your facts and circumstance. It may be a third-party created spendthrift trust taxed at your income tax rates, an asset protection trust, or a trust for the benefit of your spouse. The big point, though, is you can take an asset portfolio that has been reduced by, say, 35% and protect the upside return permanently from your potential creditors. Income tax planning for the increase in value of your investments following the end of the pandemic. There are techniques for transferring assets to older generations while you retain nearly full control. Since they have certain powers over the assets are included in the older generation's estate. When the older generation passes, provided certain conditions are met, the assets are returned to you by way of their estate plans and through their estate. This is an income tax-free step-up in basis at the time of transfer. This income tax savings is accomplished through the step-up in basis principles. As an example, say you have a $2 million asset at fair market value on January 1st, 2020, but it is now worth $1 million due to market conditions. If you transfer the asset to your parents in a certain way, you can retain control over the assets while it returns to its prior $2 million value. Say 3 years pass and the older generation member passes and leaves the asset to you under a power of appointment. You receive the asset free of income taxes. You would save hundreds of thousands of dollars in income tax savings by engaging in this transfer. My name is John Farrell. I've been practicing law for nearly 20 years, and I've been practicing law in Georgia, Tennessee, and Texas. I'm the founder of the Farrell Law Firm, and I focus my practice on estate planning and probate matters. Now, let me give you the simple steps to getting your estate plan into place. First, click the link below that will take you to my website where you can sign up for a free consultation. On the page, in addition to being able to sign up for a free consultation, you'll be able to access my free ebooks and other information regarding estate planning. Don't delay. I look forward to helping you get your estate plan into place.